You're watching Bill on Bankruptcy. I'm Lee Pacchia. We're joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go and read his daily bankruptcy column. It's available on BloombergLaw.com and also on the Bloomberg Terminal. Welcome. Sorry I botched your name there.
All right, it's happened before.
All right, so the first one up for this week, the liquidation of the Bernie Madoff Ponzi scheme. It's been quiet in recent weeks. Now we have a major opinion that affects billions of dollars in claims. What happened here?
When I read it, I nearly fell out of my chair, Lee. The district judge, Jed Rakoff, reversed himself. You don't see that very often, if ever. About 18 months ago, in a dispute involving the owners of the New York Mets, Judge Rakoff ruled that Section 502D of the Bankruptcy Code does not apply in liquidations of brokers. Now, what all that mumbo-jumbo means is the following. If a bankrupt believes there are fraudulent transfer or preference claims against a creditor, that creditor's claim is void until and unless the creditor beats off that fraudulent transfer claim. But Judge Rakoff said in September of 2011 that principle does not apply in brokerage liquidations. That was a huge loss for the trustee of Madoff. But lo and behold, he turned around 18 months later and reversed himself. I think what's happened in the meantime is Judge Rakoff, like it or not, has learned an awful lot of bankruptcy law. And he sees now the error in his ways from 2011. This is a really big deal for the Madoff liquidation because it knocks out billions, and I mean billions of dollars of claims, especially those by the so-called feeder funds. Secondarily, it also means, for reasons you can read about in my column, that bankruptcy judge Lifland will be the judge initially to hold trials on these fraudulent transfer claims. That is a big loss for the creditors who are being sued because they were hoping that the trial would be before Rakoff. Now it looks like it won't be.
Bill, a couple of professional firms learned a very expensive lesson last week. Who are they and what did it cost them for the number of the week?
Oh, the number of the week, $4 million, that is. And that's money that will not be received by Capstone, a very esteemed turnaround manager, and by Robert Manzo, a significant high-level, well, I would say employee at that firm, but he's not an employee for reasons we'll
Right, terms matter here.
Yeah, they certainly do. What happened was this. In the Chapter 11 case for a company called GSC, the U.S. trustee made an allegation in a hugely long pleading that there was an undisclosed improper fee relationship or fee splitting relationship between Manzo and Capstone. Well, guess what? They blinked and they agreed to give up, as I said, Lee, $4 million of revenue out of that case. Now, as it turns out, that isn't the only firm to take a hickey within the space of a week. In the case of Ocala Funding down in Florida, the firm Cadwalader, Wickersham and Taft from New York agreed to pay back $125,000 and to waive a $1.6 million claim. Now, this one actually, Lee, falls within the ambit of what I always say, never be an eyewitness to a train wreck, because somebody will say that you put a nickel on the track and cause the derailment. In this situation, it turned out that Ocala Funding was part of the big Ponzi scheme of its parent, Taylor, Bean and Whitaker. So it's perhaps not fair for anybody to suggest that Cadwalader was in cahoots, but it just goes to show, don't be around when there's a major mess.
Wanted to pick up on the case of the week. It looks like we have another long, hard slog in the making. We talked about Washington Mutual and Tribune a couple of months back about how they were the two big bankruptcies that would, for what seemed like an eternity. These cases just went on and on and on and ate up hundreds of millions of dollars in fees. ResCap now looks like it's going to take the place of WaMu and Tribune. They're both, of course, out of the system now. What's happened in ResCap to make it get that moniker?
Well, it's a horribly complex case. I think the theory now is if you throw enough outsiders at it, these folks will get together and settle. We already have two bankruptcy judges, not just the judge in the case, but two other bankruptcy judges involved. We have an examiner, the former bankruptcy judge Arthur Gonzalez. We also have a sitting bankruptcy judge, Jim Peck, who is serving as mediator. That evidently is not enough So they brought in another outsider, none other than Lou Kruger from Strzok & Levin, a very fine, very senior, very savvy, very tough lawyer. He will serve as the chief restructuring officer. Maybe, just maybe, these three people together can crack enough heads to bring about a settlement. But this makes me think, Lee, I believe we need to reconsider how to get these huge cases finished. Because quite frankly, when you're talking about situations where professionals make hundreds, and I mean hundreds of millions of dollars out of cases, there is not a whole lot of incentive to settle.
For sure, it's not a good sign when you have 3 bankruptcy judges in the case.
Maybe what we should have is a situation like this. If you have a complex case or even a simple case, if the parties cannot reach a settlement after 3 months, well, guess what? You bring in somebody, call them maybe a receiver, and that receiver will impose a settlement on everybody. And I guarantee you, if there's a prospect of having a settlement imposed that essentially cannot be reviewed by a court, people are going to settle the day before the receiver comes in.
Yeah, I think I just heard Chris Whalen somewhere shout. I'm sure he can get on board with that idea.
You know, that would be an awful lot like some aspects of Dodd-Frank.
Sure.
And I got to tell you, we ought to consider this because cases like WAMU, Tribune go on forever.
Sure.
4 years.
This is the 3rd one we've seen in our time together. So let's pick up on the stats section. The week, of course, would not be complete without a visit to the statistics section and some musings on numbers. What are the newest figures affecting the bankruptcy courts?
Okay, take a vacation this year because there is only $21 billion of bank and bond secured debt maturing in 2013. But don't give up hope, because if you can live until 2017, there will be about $260 billion of bank and bond debt maturing in that year. One of these days, Lee, this merry-go-round is going to stop, and these hundreds of billions of dollars of very junky debt are going to mature, and then, finally, bankruptcy professionals will be in, shall we say, in heaven.
Mm-hmm. And we're seeing a lot of new covenant light bonds coming out. I think it's the highest amount this year since 2007. That's pre-crisis.
Oh, absolutely right. We have gone back to a covenant-light atmosphere. It's like nobody learned their lessons from 2006 and 2007. Mm-hmm. You sell junk debt at remarkably low interest rates with virtually no covenants.
Finally, we're going to touch on the advance sheets. Bill, when we discuss important new bankruptcy opinions, we usually talk about cases from the courts of appeal. This week's decision is by bankruptcy judge Chris Klein in the municipal bankruptcy for Stockton, California. What does he have to say?
Very important decision, and very correct, I think. He said that if you are a municipality in Chapter 9, the municipality can make a settlement, or get this, Lee, pay claims, without going through the Chapter 9 plan process. He said that because of constitutional restrictions, municipalities could do these settlements without court approval, a really big deal. He then went on to say something that I'm not so sure is entirely correct. He said that if, however, you do pay claims before you consummate a plan, that may bar you from establishing good faith or lack of unfair discrimination, and thus prevent you from confirming a Chapter 9 plan. What I am concerned about is I'm not sure that the same confirmation standards apply in Chapter 9 as they would in Chapter 11, because I don't think you can impose a standard on a municipality indirectly that you cannot impose directly. So for that reason, I'm not so certain that the dicta at the end of that opinion is good law, but I suppose we will find out one of these days.
Good to be important and correct at the same time. That's something I like to think I aspire to. Bill, thanks for stopping by. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases or issues we just ran through, be sure to go read Bill's column. It's available, as always, on BloombergLaw.com and also on the Bloomberg Terminal. I'm Pacchia. Thanks for watching, and see you next week.